All right, you're host now. I'm gonna leave.
Okay.
If you
Thank
want, you can call me on my phone.
Okay.
When you finish, so that I'm alerted to do the other part.
Okay.
Thank you.
Thank you so much. Hello out there in Zoom land. Just want to let everyone know, because I thought there might be more interest than Zoom boxes, that I could potentially look at first thing on Monday morning. We are live streaming on YouTube. So if you all have more people other than the attorneys that you would like to have watched the proceeding, go to the commission's website, and Anna has put a button for YouTubing, and again, so that you all know not that your conduct would be any different in the Zoom meeting than it would be on a live stream. I just put that out there for you, that we're being live streamed on YouTube. And I believe, except for Major Buchanan, I believe we have all of our participants.
Ma'am, this is Drew Jernigan from the Federal Executive Agencies. I will be here for Major Buchanan.
Okay, good morning.
Good morning.
Also, just to let Mr. Jernigan, if you have not appeared before, normally I do require in these proceedings that I be able to see you. Oh, there's Mr. Marks.
My
Hello
apologies,
there, Mr.
ma'am.
Marks. Can you make yourself visible?
Not with this computer. I tried that when I logged in and it crashed on me. So I don't know if it's a bandwidth issue or computer issue. I'll have to talk to my IT before our next meeting. I apologize.
Okay, very well. I understand that. Mr. Gatko?
Madam Hearing Examiner, I am struggling to get my camera on my laptop to work correctly. That's why I came in and I came out and tried to get things restarted, and it just doesn't seem to want to work right now.
Well,
I'll keep
I don't know.
working on.
Okay, I don't know if you're here or not, but our head of IT, Miguel, is actually in the building. If you need assistance, or Mr. Bagacco, I've always kept, as a daughter of a carpenter, I've always kept a claw hammer in my desk drawer, just to kind of shake at the computer. Of course, I would never use it because it's state property, and then I'd have to pay for it if I actually hit the computer. But sometimes if it doesn't help, it's made me feel better. So
I got in big trouble last time I used a hammer to fix a computer, so I'm going to probably just call Miguel here in a little bit.
Yeah, that might work for you. Okay, let me see. Ms. Lee's Mr. Walker. Who is Comer, and why do they need in this meeting? Or can they just go again for any late arrivals? We're being live streamed on YouTube. So if you have clients or others or friends that you think ought to watch this meeting, it's on YouTube, and you can go to the commission's website and just Anna's put the button on there.
Yeah, yes, Your Honor. Mark Walker, Southwestern Public Service. I'd asked him, he's our regulatory manager on this proceeding, and in case there were any scheduling issues, I just wanted him to be handy, but if he can watch it on YouTube, we've let him know that. So hopefully he's figured out how to find it.
Okay, I just let him in, so he can do either. Like I say, I just trying to keep people's faces and and trying to get us going. Well, you know, it's time for our pre-hearing conference, and thank you all for appearing here today. We are here in the matter of case number 22-00155 UT. And this is in the matter of Southwestern Public Service Company's advice notice 303. And I'm assuming all the people here are in the right place. If not, if you're here for the grid mod case, that's going to be at 11. Okay. Well, hello, happy Monday morning, and we are here to discuss setting a procedural schedule for this case. Although, and I was provided, and I believe the parties were provided a proposal for this case by SPS last week. And I have looked that over. I do have issues with that that we can discuss here today. I also have issues that I want to discuss about what kind of case is this? So I don't know if parties have any other procedural matters that you want to discuss, but obviously let me know if you do. And we can start out with what kind of case is this? When I first looked at it, I thought that this was just a typical advice notice new rate case with the for a standby rate, and was being offered by SPS in conjunction with an agreement that parties made in the stipulation in their last rate case, case 20-00238. But then, as I read the commission's order last week, I see that there were protests filed, and the commission has termed a complaint. And I believe, Mr. Marks, that you filed the protest and complaint along with Ms. Lynch for CCAE. That's correct, sir?
Yes, Ms. Hurst. The large customers filed the protest. Ms. Lynch and I for RIA and CCAE, we filed a protest, and we also threw the word complaint in it because the statute says upon a complaint, you go to a hearing on a rate. So we will kind of belt and suspenders approach, and the commission definitely construed our pleading to be a formal complaint, and thereafter required an answer to it. Although I can, I don't know if this is against interest, the commission never charged me the $25 that you normally pay for a formal complaint, but I do believe, since you had just cut me off, you can do that anytime, I'm sure, Ms. Hurst, but my clients, and I think all the parties, want to get to the merits, and the merits are going to be SPS's proposed rate, and then I expect we're going to see the large customers are going to file something as an alternative, and they could speak to that, but we want to get to the merits and not worry too much about the the formalities of a formal complaint.
Okay, and that's what I'm getting at, just so that I'm able to identify the structure of this, Mr. Marks, and really, if this really is not a if this really isn't a formal complaint, as we're familiar with them under under 1.2.2.15. And because this has been suspended by the commission, I believe, in their order, due to your protest, can we structure then this procedural schedule and consider that that your complaint was to try to assure that a hearing would be held, and since that's going to happen, that I don't need to consider your protest as a formal complaint.
Yes.
Okay. Very well. And that's okay with you, Ms. Lynch?
Yes, Mr. Marks represented our position clearly.
Very well. Okay. All right. Well, that takes care of that particular issue. My other, in trying to get looking over the pleadings and the commission's order in this case, along with the proposed schedule, and is Ms. Lees, in your email, in the proposed schedule, I think you had referred to SPS testimony by indicating that and also Mr. Walker, that you didn't think you needed to file testimony, but that if you were made to file testimony, that you could file that on or before September 26th. Is that correct?
Yes, Your Honor.
Well, I think you have to file testimony in support of your new rate. I also think you need to provide me with the draft notice, which I did not.
We will get that to you today, Your Honor.
Okay. And what we're going to talk about in the next case, but some of you might not be in the next case, is try to put my hearing date further up in your notice. Because I got tired looking through all the things I know you have to put there. I'm really not being facetious. I just for decades I listened to the complaints of ratepayers who, thank goodness, actually take the time to look at the back of the co-op little magazine, or look at your bill stuffers, or when they're paying their bill, they actually look at the notices. And so I'm real happy about that. And but I don't ever get any calls that say, boy, that notice, that was in my bill and in my SPS bill, boy, that was clear. And that just very cogent and thank you. Okay, no, I get the ones you put so much gobbledygook in there and all that legal stuff. I have no idea. I just take one look at it, and it's not helpful to me. So we're always striving to try to make these things as clear as possible. So the getting to the point quicker. And again, I understand that, there's certain things that we have to put. The other thing that I did not see in there, and I love it, is when you put one sentence that says somebody's phone's ringing and it's mine. Uh-oh. Hang on just a second. It's Mr. Bagatho. Yes, sir. Is that you on there that says Noah? Okay, I'll admit you. Okay. Right. I had an unknown name and that's just something else. If I have an unknown name and no one can tell me who it is, I'm not gonna let you in. I really don't want to be Zoom bombed today or any day. Okay, so that was Mr. Bagatko and now I don't see him, but if that prompt comes up again, there he is. Okay.
Madam Hearing Examiner, this is Joan Drake. I just got an email from Katie Coleman with Oxy and she's trying to get in as well, but apparently she didn't have the Zoom information. May I go ahead and email her the
Yes.
Zoom invite?
Yes,
Okay.
go ahead.
I will do
Thank-
that now.
Okay, thank you.
And Madam Hearing Examiner, this is Sydney
Hi, Ms.
Beatles.
Beatles.
Recognizing that we haven't formally filed a motion to intervene. I do have a question about notice, but I'll wait until, I think you were making a point about notice, and I'd like to follow up with a question.
You'd think I was making a point. Obviously, I didn't make the point. Anyway, oh, my other point was with notice, at least in the rate cases, and I think it would be appropriate in this case, how I like the one sentence that says that typical customer for this group, whatever that, we sort of laughed over decades about, is it the average customer? What's the typical customer? But if we have that information, Mr. Walker, I kind of would like to have that in the notice too, for the groups that you plan, the group that you plan on charging the standby to, what that could look like.
Identify the customer classes eligible or potentially affected. Yeah.
Yes, sir. And then tell me, okay, it's going to be $2 more a month or whatever. Again, I think if I recall correctly, SPS uses the phrase typical.
Right.
Typical customer.
We will show you what we have, and this is kind of an unusual tariff because it's difficult to predict that. Depends on the customer
Sure.
and how they're put together, but we will do we are working on that for you, and we'll give you something today to look at.
Okay, just send that to everybody. Okay, so with those kind of things about the notice.
Well, Madam Hearing Examiner.
Yes, ma'am.
I'd like to ask you and SPS to also at least copy the parties to this pre-hearing with the draft proposed form of notice, and maybe if we could just have 24 hours to provide you with any comments on it.
Sure. And I just asked him to provide it to the parties.
Oh, okay.
So, but yeah, I'm more than happy to, again, make that notice better. It's right. I'm gonna require that you serve it individually. Are you planning on bill stuffing it or separate?
I believe we're doing publication. I don't know, Jeff Comer, if you could respond to that. You there, Jeff?
Unmute yourself. His little box is there.
Zoe, do you recall how
Yeah,
how we're
so
doing?
we typically, in order to send out notice to customers, we'll need 2 weeks from whenever you provide us that notice, Hearing Examiner Hearst. So the bill stuffers, it's a lot more of a lead time for that. So we'll probably just be sending the notice out separately, and we'll need 2 weeks from the date that you provide us that notice in order to do that.
Okay. Just trying to see, I believe I've been told in the past that it's more cost effective to potentially to build stuff. So I just wanted to offer that opportunity. And you can change your mind if you want once we get the thing ready or not. Okay, so the parties can weigh in on the proposed schedule. There seems to be a difference of opinion, we think, on the appropriate house to put this case in. Should it be a standalone house or should it go into the rate case? And if I recall correctly, I have views on both sides.
Madam Hearing Examiner,
Ms. Beatles?
I requested to be excused from that rate case. So is there a question in this case of whether the statute 62-13-13.2 governs this proposed rate? I assume it does apply, but is there an issue there?
62-13.
Governing the information that must be provided in support of charges for ancillary and standby services.
Okay, I've not got the right. I've not got your right side. 62-13.2 is about fees.
I'm sorry. 62-13-13.2. It just says that the commission shall assure that costs to be recovered through the ancillary or standby service rate riders. The commission shall ensure that they're not duplicative of costs to be recovered in underlying rates and shall give due consideration to reasonably determinable embedded and incremental cost of the utility to serve the interconnected customers and so forth. And also to reasonably determinable benefits.
Okay, so your question is
I assume it applies.
You're going to argue that that's applicable to this case.
Well, I assume it applies. I just wondered if that's an issue that has potentially been addressed or resolved by the rate case. I don't believe that it has, but I'm not as familiar as others.
And I guess that remains to be seen. My recollection of the extent, Ms. Beatles, that the standby rate was determined by the commission is limited to what was proposed in the certification. So I think you have to look at the specifics of that particular section in 20-00238, and I guess just to sort of paraphrase that, it said that it was going to be, the standby rate was going to, I believe that was paragraph 7, page 6 of this stipulation. SPS agrees to file a standby rate tariff within 90 days of receiving final order in this case, including a standby tariff that's appropriate for a solar generation facility. SPS will confer with interested parties designing that tariff. And I believe that's the extent that standby rate was dealt with in that case.
Okay, thank you. I think to better refine my question, I assume that the requirements of that statute then continue to apply, and that information, I guess I was wondering whether that information had already been provided in the rate case. I don't know that it was or wasn't, and I just want to make sure that that information in the studies supporting it will be made available by the company in this case.
I think that since nothing was determined in that case on the previously filed one, my observation, Ms. Beals, would be that whatever SPS determines they need to support advice notice 30 or 303, they're going to offer in order to meet the evidentiary burden in this case. I don't know, Mr. Walker, do you want to give a preview of I think they call them trailers nowadays. When I was growing up, they called them preview of coming attractions.
Right.
But if if you want to give us some information about what in SPS in fact plans to file in support of advice notice 303, please go ahead, sir.
Yes, Your Honor. The approach we took was to follow the guidelines of the commission rule on standby rates, and that references back to the limitations based on whatever rate applies to the eligible or the target customers. So all that information, yes, would be in the rate, have been addressed in the rate case, but also in the tariffs that are current. And it's basically the backup charge is 10% of whatever that is. And so that it's pretty simple. And that is why we initially thought the affidavit might be sufficient. We're happy to do the testimony as well. But at any rate, so that's the shorthand version is the rate itself is simply 10%, and that's pursuant to commission rule of what the demand rate would be otherwise.
Any chance that while we're talking about this specific item, any chance you could file that earlier, say September 16th?
Yes, Your Honor. Absolutely.
And Madam Hearing Examiner, this is Joan Drake.
Yes, ma'am.
I think in our email response to all of this group, we had suggested September 1st, which is almost 3 weeks from now. So just to give us all a little more time for discovery if folks need that. But we had no objection to the rest of the schedule, but I just wanted to bring to your attention that alternative proposal.
Okay. Can you file it by the 1st?
Your Honor, could we maybe split the difference and go for the 7th or 8th? We just have a lot going on right now, and we have one resource that's spread pretty thin right now.
I don't have a problem with that. In looking at what kind of deadlines that I thought might be more appropriate, I was looking at 16. Any objection, Ms. Drake or other purported parties to having it filed on the 9th of September.
I think that's okay. That gives us that gives us about 6 weeks. So hopefully that should be enough for, a couple rounds of discovery as needed. But I would, that's my own view. I would ask other folks to chime in if they have different views.
Okay. Not hearing from anyone else. Okay, I think, that I think can start us out. If I get what I think is an appropriate notice, I can issue the procedural order and notice. If not the 17th, the 18th. And depending on that and based on what you've had to say, Ms. Lee's, then I would assume it would be either filed by the 31st or the notice sent out by the 31st or the 1st. And then, I think that would be fine to have a September 30th intervention date. If we get those things accomplished in an expeditious manner. Then I have on this, I have a staff and intervener testimony due by the 24th of October. Got rebuttal on December. I think that's too long for rebuttal, and would propose the 14th of November for normally. Yeah, normally that's what we give is a couple weeks for rebuttal and not like 6 weeks.
Ms. Hurst.
Hi, Mr. Marks.
Hi. I would object to shortening the rebuttal from what the company proposed. As I alluded to earlier, and as Mr. Walker has pretty much clarified, the company's proposal is pretty simplistic. They took 10% of the current rates and are proposing it. I think we still don't understand how you apply it, and I'm not sure they understand how to apply it, but we will get at that in discovery. But what I think is going to be a lot more complex or intensive analytically is if the interveners, such as large customers, come back, and I think they're going to make a rate proposal because they did in the last rate case. So there's going to be a full-blown rate proposal in intervener testimony, and it's not going to be ours, and we're going to need some time to do discovery on it and respond to it. It's going to be meatier than the company's proposal is what I'm anticipating.
And Your Honor, the other issue we have is we will be filing our next rate case about that time in November, and we have our resources will be pretty spread thin, and then we have the Thanksgiving holiday. And so our thought was we give us the breathing room we need to finish filing our rate case, let folks have a little time off with their families, and then we could get the rebuttal finished up shortly after the holiday. That would give us a week or so after the holiday. That's why there's that long stretch there.
Again, you all know your positions. I don't yet, and I can't until you formally file them, of course. I just think you're looking crunchy with regard to to your testimony deadlines, proposed stipulation deadlines. And I'm not going to get caught in the crunch like I did a few years ago, where negotiations are going on during or in between the holiday. I don't find out about it, and then I'm faced with a bunch of motions to continue things at the beginning of the year, especially on something that that has been suspended. And so, you know, we're going to have to come up with something, because basically, to me, if you want that December 2nd on your rebuttal, then you're going to have to shift the rest of those dates up 2 to 3 weeks. And that's not going to be acceptable to me, because I believe, if I remember correctly, the 9-month suspension date on this is the Ides of March. And which means if you back that out a month for the commission preparation, I'm not going to have time to write an RD. If this is when the hearing is at the end of January. So something's going to have to give somewhere. I mean, anybody think I got that suspension date wrong? Yep.
That's the date I calculated as well.
So, while I appreciate, you know, needing time, and I'm not going to be, you know, I'm really not wanting to be in a position that I'm not going to have the testimony. I want the testimony in the record prior to any definitive stipulation filing. So, I mean, I don't know if you all want to talk about and try to come up with something, but like I say, right now, you know, the rest of the when the hearing's proposed, etc., is really crunching up on my time and the commission's time. You know, basically you're giving me and the commission between us 6 weeks to write a decision, get exceptions, and have a commission decision, understanding that this is going to be a new, you know, a new commission. You know, they might want some time to look at this, or potentially send it back. And so that's kind of what we're faced with at this point. So,
Your Honor, would it be possible to agree to an extension, a further extension of the suspension period to allow that extra time? The other option that Zoe suggested was maybe move. Well, I don't want to put Zoe on the spot. I don't want to hang her out to dry or anything, but she's clever on these things. The moving the stipulation deadlines to maybe before rebuttal.
nope. No, that's why the, you know, that's what it looked like to me, that the only time that, you know, when I was looking at this yesterday, the only movement that I really saw, you know, is if you file your testimony sooner. I mean, you know, we could cut some of the staff and intervener testimony. You know, I mean, we can try to shave, you know, a week or two on the rest of those dates and bring us back, you know, in line to actually having a hearing at the beginning of January. You know, and then obviously if there, you know, if there were some kind of stip, then, you know, as I have usually started to do, that, you know, I'm going to put in there that, you know, the language that parties are in agreement that the statutory deadline can be told during the negotiation up to a final order. You know, I mean, obviously that, you know, that tolling gives some flexibility, et cetera, while understanding that, you know, if there's not some type of agreement that's potentially available, then we want to get it heard and come up with a decision, because this is a rate that you know, that the company is entitled to have commission action on. So I don't know, people, what?
Your Honor, can we try to move the hearing back to like January 5th and then adjust these other dates after the rebuttal? I think there's room to squeeze that a little bit.
Well, and I'm more than happy to, you know, to let you all, you know, to let you all discuss this. You know, again, you know, when we get crunchy around the holidays, and then everybody's you know, everybody's plans and everybody's in, especially she said selfishly, the commission's into the work time crunches with renewables and you know, the usual cases that all come in. You know, it can be it definitely can be challenging. Plus, you know, going back to my you know, going back to one of my earlier questions, you know, there was still, at least in your written, you know, in your written pleadings that you've already filed in this case, you know, there is, you know, or there are parties who think that this whole issue would be better left not in a separate proceeding. That's why I was saying, whose house is it in? Is it, you know, it's not in a complaint house. Okay, now, so we've got that straightened out. But yet, you know, we are in a position where some of the parties think it's appropriate to have this considered in a rate case. And then there's other parties that say, no, you know, we've tried that before and it hasn't worked. You know, there's so many issues in a rate case, and, you know, this issue is deserving of, you know, a discrete, you know, a discrete proceeding all on its own. And quite frankly, you know, the argument that's been made that, hey, wait a minute, you know, this was a bargained for agreement in the rate case that, you know, that we're entitled to have a determination on. Not in a separate case, but this came out of the last case. And, you know, I mean, I have to say that, not to mention the other agreement of, I believe one of the parties to say, hey, you know, we're interested in this, but we might not be interested in a whole rate case. You know, why should we, you know, have to participate in, you know, in that? But the bargain for agreement, you know, argument, I think is substantial and really lends itself to me, that we continue, as the commission has started in this case, by having the suspension period and it's, you know, for this one rate. Any objection, let me put it that way, any objection to us going forward as a standalone case on rate, on the standby rate?
Ms. Hurst, no objection. My client strongly supports that. We were agnostic as to whether it should be a standalone or a part of the rate case. There are pluses and minuses, but it would be unfair to the interveners to have to spend the money to litigate this case only to have your honor say at the end, well, I think you need to litigate the rate itself in the rate case. I mean, we if we're going to do it, we need to come out of this case with a recommended either that there is no just and reasonable rate, or a recommended decision recommending a just and reasonable rate. We don't want to litigate this twice.
Right, and I wasn't suggesting, Mr. Marks, that we were going to have two. I just wanted to find out which forum was going to be the appropriate one, whether it be this forum or the, again, and I can't remember, and I'm not finding my note quickly. I believe staff was one of the participants that wanted to defer this to the rate case, but there may have been more. Mr. Walker.
Ms. Hurst, if I could say one more thing. Yes, staff did recommend it, but the commission, their order is not that well written, that clearly written, but the commission clearly rejected that. If you look at their discussion in their open meeting, they wanted to, they were concerned about the arguments made by the large customer group that they've been waiting for this for a while, and the commission said they shouldn't wait any longer. They shouldn't wait for a rate case. So I think they didn't, you know, their choice in the order that they issued appointing you or sending this to a hearing examiner was either to say this should go to a hearing examiner, or a company refile this as part of your rate case that you're going to file in 2 months anyway, and they send it to a hearing examiner. So I think that question is decided.
Okay, well, I actually did not hear of the discussion on this, Mr. Marks, but again, I just wanted to find out whether or not any of the purported parties and participants at this point is going to have any objection to us proceeding in this case. And
Madam Hearing Examiner.
Mr. Bagatko, hello there.
Staff is still of the mind that it would be more appropriate and efficient and economical to do it in the rate case. I'll just restate that. But if you end up deciding to have this as a standalone proceeding, then, you know, we will, of course, participate and go in that direction. But I just wanted to restate that, since you did correctly note that was our position.
Okay.
And Your Honor,
Ma'am.
Thank you, sir.
SPS, I think we're of the same mind. We do believe it would more efficient for this to become part of the rate case, but we will certainly, participate as you direct.
Okay,
And Your Honor, this is Nick Stoffel for the large customer group. I'd just like to note staff and SPS were parties to the settlement that agreed this would be a separate filing.
okay. Very well. Anybody else want to weigh in?
Ma'am, this is Drew Jernigan for the fellow executive agencies.
Yes, sir.
My client is also kind of leaning towards the efficiency of the other option of having this as one rate case. The concern mainly being that we're creating a tariff that, while we're also creating a new rate case, and the incorporation of the two going on at the same time will create difficulties for both. And that would be why we'd be leaning that direction, since you raise it. Whichever way you go, of course, is the way we will proceed. But that concern of having to deal with an uncertain rate in the rate case at the same time is what's driving that for us.
All right. So noted. And obviously, as we all know, in this particular business, sometimes our future plans change, and I think pretty much based on what I've read and heard the parties' positions, I do believe it's appropriate for us to go ahead and set a procedural schedule and to take this rate in this particular case separately. And should their SBS had filed its rate case near the end of the year, as Mr. Walker has indicated that they plan on doing, then what effect this decision might have, if any, in that case. I believe the parties will let the commission know about any potential effect in that particular case. Okay, so now we know that we're going to proceed in this case on this particular rate. We're still left with the proposed schedule.
And ma'am, this is Joan Drake again. I was looking at the calendar and I'm wondering, it sounds like you'd be more comfortable if we moved up the hearing date by a week or two in January to give you more time on the back end. And I'm hearing what Mr. Mark says about potentially needing more time for discovery before rebuttal is due. So I'm wondering if we sacrificed a week of on staff and intervener direct testimony and pushed that up to October 17th. I think that still gives us time for a couple rounds of discovery on that end. And if we pushed the rebuttal date to November 28th, I know that's right after Thanksgiving. But if we pushed it up to that date, that seems like it would give enough time for maybe 2 or maybe even 3 rounds if we're efficient and expedite things. And that may give you enough breathing room in December and early January to get the hearing set in maybe the first couple of weeks in January. So I wanted to throw out that notion.
And I appreciate that, Ms. Drake. I really think at this particular point, the parties I think that discussions among yourselves might be helpful because I really don't, in looking, I mean, are we really gonna need 4 days?
For the hearing, Your Honor,
Yes,
I just, to be honest, I stuck it in there because that's the number of days we had in the grid mod case. I don't think so, but I haven't seen yet what others may propose.
okay, I mean, we're talking. Okay, right now we have potentially we have 7 participants, right? I mean, potential interveners. Plus staff, plus the company. Is that right? 1, 2, 3, 4, 5, 6. No, that's including staff. So say eight participants. Is anybody going to have more than 2 witnesses? Potentially, so, you know. So even if everybody had 2 witnesses, that would be 16 witnesses. And we potentially could get, you know, get through 5 or so a day. Mr. Bagatko?
Madam Hearing Examiner, we will have 1 witness for staff.
For the NMLCG, we also expect to just have 1 witness.
CCAE and RIA are thinking just of 1 witness.
And for LES, we would likely just have 1, and I would defer to Mr. Jernigan if FEA would join on that. So we may, between the two of us, just have 1.
Ma'am, this is Drew Jernigan. Yeah, that is likely, although I can't commit to that at this time for procedural reasons within the Air Force. So,
Okay. Okay, so chances are we're probably not going to have more than 10 witnesses. 8 or 10. Okay, anybody think at this point we can't get it done in 3 days?
I certainly hope not. I would think 3 days would be plenty.
So yeah, I mean, if we were looking at potentially the 4th, 5th, and 6th. So I think if you use that as a, I'm not hearing any wailing or gnashing of teeth, at least yet on that. And so if we were looking at that and then back your way up, with the other dates, you know, leaving alone. Right now, what we have is notice going out by the 31st or the 1st. We have SPS testimony deadline of the 9th. We have an intervention date of September 30th and potentially a hearing January 4th through 6th. So, you know, if you look at your staff intervener, your rebuttal, your STIP deadline, your opposition, which doesn't change, it's always 5 days. Your testimony in support of the STIP, in opposition to the STIP, and then a pre-hearing conference. You know, potentially, I guess, on the 3rd, and it could be that week before the end of the year. I can tell you at this point, I plan on not going anywhere. During the month of December that I know of. And we could have a pre-hearing conference, but again, understanding that people have other holiday obligations in addition to their work obligations, I would leave that for you all. So I think you all are going to have to decide what you really need and what you can do. And I think you should be, unless I hear a different suggestion, I'm going to leave it to you all to send me something that you think I can live with based upon our conversation here today.
Your Honor, if I may ask a question,
Yes, sir.
is the commission planning on operating remotely during the time we're talking about the hearing, or would that all be required in person? That may
Wow.
make a difference as to travel.
Yeah. Mr. Jernigan, that's an excellent question. And I guess I'm going to have to waffle a little on that for two reasons. First has to do with any health considerations that I think just changed again on Friday. And people's specific medical needs and tolerances and second, our hearing room that's currently available to us is, I don't know if any of you all have been in it yet, but it's not very big. And so, for example, even though I believe that the guidance has been changed on a 6-foot requirement, so we actually could get more people in there if the parties are willing to be close to each other. But we still can't get a whole lot of people in there, and that's why I'm cautious in saying there may not be an in-person requirement. I'm also cautious because we might have a new commission that, who knows, if they made an edict when they came and said, oh, and we want all of the hearings to be in person. Not to mention the fact that, if they decided they wanted to start having hearings again, like this commission on Wednesday, we would be in their hearing room if we're doing the 4th, 5th, and 6th. So with all of those, I hate not to be able to give you a definitive answer, Mr. Jernigan and everybody on the call, but I probably am going to put either or on there, and potentially, and we have not gotten it worked out yet. So I kind of hate to throw out the possibility of a hybrid, but we don't have the camera and the sound available yet to be able, I think, to effectively run the hearing so that the Zoom presence would be equal to the benefit that the people who are in the hearing room get. So with all of that, Mr. Jernigan, probably will be Zoom, but stay tuned.
Thank you, ma'am. That just for travel purposes, I wanted to know if I was going to need to ask everything be close together or separated as you were discussing. So given what you've said, I'm probably going to be leaning towards together if we could. So,
And I will, you know, obviously I'll try to let people know as, you know, as I am told. Because ultimately that's, you know, that's how I have to operate. I mean, the commission tells me to, you know, have a hearing a certain way, then I pretty much have to do that. Okay. All right. Anything further? I'm going to leave it up to you all. Again, based on what I've said today, understanding, working your way back. You know, I think you all can come up with something that, you know, that I think will be agreeable to everybody. You know, I have faith in you.
Your Honor, just one last ditch effort to see, I think with the I'll call it the back end dates that you've indicated on the pre-hearing conference on the 3rd and the hearing 4th through the 6th, if we just moved back the testimony and opposition stipulation to December 29th, that I think would make this all hang together.
Yeah. I was actually thinking the same thing. So if we could just move that date back and keep all the other dates, it seems like we could get to the hearing that first week in January.
Certainly is not going to give people necessarily much of an opportunity to review that testimony in preparation for the hearing. I don't know, is anybody opposed to that? So basically, just so that we're all on the same page, so that I'm on the same page as you are, basically then what we would be looking at is SPS testimony on September 9th, intervention the 30th/1st, depending on when I get the notice and issue the procedural order. Staff and intervener testimony on the 17th. Rebuttal testimony on the 14th. Stipulation 14th or 28th.
28. That's what he said.
Okay.
Oh, I guess I misunderstood, Your Honor. I think we were trying to keep the other dates the way we had them originally proposed. With that change,
that you had them originally proposed.
right?
Okay, well, that doesn't work for me. So basically, what I was looking at is staff and intervener testimony on the 17th of October. Rebuttal testimony. Weren't you suggesting, Ms. Drake, that it be on the 14th? Why did I write the 14th?
I don't know. I think I suggested the 28th.
Okay. Let me mark that out then. The 28th stipulation, the 8th opposition to the stipulation, the 12th testimony in support of the stipulation on the 19th, opposition, testimony is opposition of the stipulation, December 29th, pre-hearing conference on the 3rd, and then hearing the 4th, 5th, and 6th.
But
Is that what people thought?
yeah, but you know, I was just trying to respond to Mr. Walker. I don't have an objection to November 14th either as the rebuttal date. That just seems to me to give everybody a little more time to maybe talk settlement. But I don't have a preference really strongly one way or the other.
But Your Honor, if we're going to do the November 28th, which is the Monday after the Thanksgiving holiday, versus December 2nd, it seemed like that's not much of a difference to give us a few more days. And also the November 14th is about the exact time we're filing our rate case.
Okay. What if we said the 22nd?
Yeah.
If I can't sell December 2nd, I guess I'll take it.
What about the?
If we're gonna go in there, how about the 30th November?
I don't want to move it out that far. I don't want to move the rebuttal out that far because, I mean, if you've already, I mean, normally you just get 2 weeks, which would be the 31st. So, I mean, really, I mean, I understand what Mr. Mark said about, needing, some extra time, but I mean,
So-
really, the 14th would give you a month. So, I mean, I kind of think that even if you are filing your rate case, I think actually earlier would be better, something like the 14th, because then that would give you the 15th through the 23rd, before Thanksgiving, to be floating ideas, and then and then you could move your you're, I mean, I don't know if you're interested in moving your step date, but. I mean, you do have to have time, I understand, to actually do the negotiation, and it is around the holidays, so maybe you don't want to mess with that. And,
Ms. Hurst, is the staff and intervener testimony October 17th?
yes,
That's okay. We would go with, or we would, of the choices you're saying are acceptable, November 22nd for rebuttal. For the reasons I previously gave, we need time to do discovery and file response. File responsive testimony, and the company also has that conflict with their rate case filing. So,
Mr. Walker, are you willing to agree to expedite discovery?
it's
What is the response time that you have in mind, Your Honor?
I don't know. I mean, I'm just wondering if the parties want to think about that as an option at this point, and let's put it in there at the beginning of the case. And then that may help with any time crunches. So I leave it to you, if the parties want to, to agree to, some type of, expedited turnaround. Normally, I don't like to get involved in their discovery, but I believe according to 1.2.2.25, the deadline is 15 days.
Yeah.
Your Honor, given that we're going to be stretched on resources getting ready for our rate case, I would rather accept November 22nd than have expedited discovery at that time anyway.
Well, I'll leave you all to talk about that, and
Well, Your Honor, we may have, at least among the parties, we may have agreement on what we have on the table now, if that's helpful.
yeah, I think potentially we do, but it without hearing objection, it sounds like staff intervener testimony on October 17th, rebuttal testimony November 22nd, stipulation deadline December 8th. So those dates haven't changed. The opposition to the STIP on the 12th. Testimony in support of the STIP on the 19th of December. Testimony in opposition of the of any STIP on December 29th. A pre-hearing conference on the 3rd, and then the hearing from the 4th to 6th. Is that what you have?
Yes, Your Honor.
Okay. All right, it's crunchy. Could be like little dominoes if someone files to change any of these dates. So I encourage all the parties to think about that before you file that motion for extension. Okay, any other procedural issues that we need to deal with? No. Okay. Well,
Honor, we will circulate a draft notice this probably this afternoon, Your Honor.
okay. Soon is good, Mr. Walker. And then whenever you all, if you can send me something final, close the business early tomorrow. Soon as you can. All right, sir?
This is the notice, Your Honor, the draft notice.
Yes, Very well. Anything further from anybody? Hearing nothing. Thank you all very much. I appreciate it, and I may see some of you again here real soon. I have to come out of this one to go into the next one. So thank you all again. We're recessed, I believe then until January.